You look upon the bench and assume power sits in one chair. You see the robe. You hear the ruling. You conclude there is the authority. But power in court is not singular. It is layered. It is distributed. It is restrained by rules older than the dispute itself. Today, we ask a dangerous question. Who truly holds power in this room, and who does not? Let us proceed with clarity.
Understanding judicial authority, discretion, and limits. When people look at a courtroom, they usually see one symbol of authority: the judge, the robe, the bench, the gavel. And the assumption forms fast: power sits in one chair. That assumption is understandable. The judge speaks last. The judge signs orders. The judge can cut off argument. From the gallery, it can look like the judge controls everything. But that assumption is incomplete. Judges have authority. They exercise discretion. They make rulings that shape outcomes. Yet they do not possess unlimited power. Courtroom authority is layered, distributed, and constrained by structure. If you don't understand those layers, the system can feel arbitrary. If you do understand them, it may still feel frustrating, but it will make sense. And once it makes sense, you stop treating every disappointing outcome as proof of bias or conspiracy. You start seeing the system's built-in limits. Start with the trial court. A trial judge runs the proceeding. That includes managing the schedule, enforcing courtroom rules, ruling on motions, deciding what evidence is admissible, controlling what the jury is allowed to hear, and entering judgment. In many cases, there is no jury, and the judge is also the fact finder for some or all issues. Those are real powers. If a party files a motion to dismiss, the judge decides whether the complaint states a legally valid claim, even if every alleged fact is assumed true. If summary judgment is filed, the judge decides whether the evidence shows a genuine dispute of material fact or whether the law requires judgment now. If a party asks for an injunction, the judge decides whether the legal standard is met and what relief is permissible. If discovery fights erupt, the judge decides what must be produced, when, and what consequences follow if a party won't comply. But here is the critical distinction. Trial judges apply law. They do not invent it freely. They are bound by statutes enacted by legislatures. They are bound by binding precedent from higher courts. They are bound by rules of procedure and evidence. They are bound by constitutional limits. Even when a judge has discretion, it is discretion inside boundaries. That sounds abstract until you see what it does. If the law requires specific elements to prove a claim, a judge cannot waive those elements because the story feels sympathetic. If a court lacks jurisdiction, it cannot proceed even if everyone agrees the conduct was wrong. If a filing is late, the judge may be constrained by the rules that define when lateness is fatal and when it can be excused. If evidence is privileged, it stays out even if it feels like the real truth. Judges can be forceful, but they are not free range. Their authority is structured. Now let's talk about the phrase that causes endless confusion: within the court's discretion. To non-lawyers, discretion can sound like a blank check. It is not. Judicial discretion exists where the law allows a range of reasonable outcomes. Some legal questions have one correct answer under statute or binding precedent. In those situations, the judge must follow that answer, even if the judge personally dislikes it. Other questions involve judgment calls inside guardrails. Common examples include whether to grant a continuance, whether to extend deadlines for good cause, whether to allow certain discovery, whether to impose sanctions for misconduct, and many evidentiary calls, like whether a particular exhibit has adequate foundation. Why does the system allow this flexibility? Because cases are not identical. Deadlines collide with real life. Evidence can be probative or misleading depending on how it is presented. Discretion allows judges to manage real problems without the entire system snapping under rigid rules. But discretion has a second half: review. On appeal, discretionary rulings are reviewed under an abuse of discretion standard. That does not mean, would the appellate judges have decided differently? It means, was this decision outside the range of reasonable choices permitted by law? In plain language, was it unreasonable under the legal framework? Two trial judges can make different discretionary calls in similar situations, and both can be legally valid. That variance can feel unsettling, but it isn't the same thing as arbitrariness. It is the system admitting that some questions don't have one perfect answer. This is also why you'll sometimes hear lawyers say, "That's a tough standard on appeal." They are not confessing weakness. They are describing the deference built into the system. Now, the limits. This is where most misunderstandings live. First, judges cannot act without jurisdiction. Jurisdiction is not a technical detail. It is the court's power source. If the law does not give the court authority over the subject matter or the parties, the court cannot help anyway because the judge wants to. If jurisdiction is missing, the correct move is usually dismissal, not creativity. Second, judges cannot ignore statutory requirements. Judges interpret statutes. Legislatures write them. If a statute creates a deadline, an element, a prerequisite, or a remedy limit, the judge cannot rewrite it because the outcome feels harsh. If the statute is bad policy, the fix is legislative. A trial judge is not a policy committee. Third, judges cannot invent claims just because harm feels real. Not every wrong is a legal claim. Courts are not general complaint departments. They decide disputes inside recognized causes of action. If the claim does not exist in law, the judge can't build it from scratch. Fourth, judges cannot admit evidence just because it seems persuasive. Evidence has to be admissible. That means relevance, foundation, authenticity, and compliance with rules like hearsay and privilege. People often say, "But it's true." The court's question is different. Can it be proven in an admissible way? The rules are designed to filter reliability, not to reward confidence. Fifth, judges cannot become your lawyer. Courts are adversarial. Parties present arguments. Judges decide them. A judge can enforce rules equally, but cannot coach one side on how to win, rewrite sloppy filings into strong ones, or hunt for arguments a party forgot to make. When people expect a judge to fix their case, they are asking the judge to abandon neutrality. Sixth, judges cannot award relief that is not properly requested. Courts generally decide the issues the parties put before them. If you did not plead a claim, you usually can't obtain its remedy. If you seek the wrong remedy, you may not get the right one simply because the judge thinks it would be better. There are limited exceptions, but the default is courts rule on what's presented. Seventh, judges cannot ignore preservation rules. Preservation means you raise issues at the right time in the right way. If you fail to object when required, or fail to raise an argument in the trial court, you often lose the ability to raise it later. This is not cruelty. It's structure. Without preservation, appellate review becomes a moving target and trials become pointless rehearsals. Eighth, judges are constrained by ethics. Ex parte communications. Private communications about the merits of a case without the other side present are generally prohibited except for narrow administrative matters. The system is built to keep decision-making transparent and on the record. If someone imagines judges taking secret calls to fix cases, they are describing conduct the system is designed to forbid. One place this becomes obvious is in what the judge can notice on their own. People assume judges can just look something up, connect dots, and announce the truth. Courts can take judicial notice of limited categories of facts, things that are not reasonably disputed, like the date on a calendar or a publicly recorded statute. But judges are not investigators. They generally cannot supplement the record with their own research into disputed facts, and they cannot treat social media, rumors, or personal knowledge as evidence. If a fact matters, the parties usually must prove it through admissible evidence. That's another limit on power that surprises non-lawyers. Another misunderstood limit is the judge didn't read everything. Courts often face heavy dockets. Judges rely on briefing rules, page limits, formatting requirements, and schedules to manage volume. When a filing is long, repetitive, disorganized, or unsupported, the court may not comb through it, searching for a coherent argument. That isn't laziness. It's triage inside a system designed to function at scale. The practical lesson is uncomfortable but real. Presentation and compliance with rules affects outcomes because the system is built to reward clarity and punish chaos. This also explains why self-represented litigants can feel like the system is against them. Courts must be neutral. They can't become your advocate, but they also can't ignore the rules for you. Many judges will offer limited procedural guidance, like explaining what a deadline is or what a hearing is for, but they won't craft your claims, build your evidence, or correct your strategy. So the power you think the judge has, "Help me because I'm not a lawyer," is often power the judge is not allowed to use. Now, at another layer most people forget, the jury. In jury trials, the judge decides the law and the jury decides the facts. That split is foundational. The judge instructs the jury on legal standards, what must be proven, what the burden is, what the elements are, what defenses exist. The judge also filters evidence, deciding what the jury is allowed to hear. But within those boundaries, jurors decide credibility. They weigh testimony. They resolve conflicts in evidence. A judge may privately think witness A is more believable than witness B, but if the jury reaches the opposite conclusion, the jury's factual finding usually stands unless it is legally unsupported. Judges can set aside verdicts in limited circumstances, but they do not routinely substitute their own fact-weighing for the jury's. This is why some people leave a trial saying, "The judge let it happen." Often, the judge did not let a result happen. Jurors decided facts inside the legal frame the judge was required to apply. Now the appellate layer. A lot of people think an appeal is a second trial. It is not. They do not hear new witnesses. They do not take new evidence. They do not redo credibility assessments. They review the record created below, filings, transcripts, admitted exhibits, and rulings. If it's not in the record, it does not exist for the appeal. If an issue wasn't raised below, it may be waived above. That's why lawyers obsess about making a record. The appeal is built out of what happened in the trial court, not what someone wishes had happened. Appellate courts also apply standards of review, and standards of review are where a lot of disappointment is born. Legal questions like statutory interpretation may be reviewed de novo, meaning without deference. But many decisions are not reviewed that way. Factual findings are reviewed deferentially because the trial court or jury saw the witnesses live. Discretionary rulings are reviewed for abuse of discretion, and many errors are treated under a harmless error concept. Even if the trial court made a mistake, the appellate court may affirm if the mistake likely did not change the outcome. That structure limits appellate power on purpose. Without it, every case would be endlessly relitigated. Finality would collapse. Trials would become preliminary drafts. Now let's talk about how power shows up outside the courtroom. Leverage. Litigation is not only about who is right. It is also about what can be proven, what can be compelled, and what risks each side can tolerate. Power can come from discovery, from timing, and from cost. For example, the ability to demand documents, take depositions, and force sworn testimony can shift the balance of a case. But that power is not free. It's regulated by proportionality and relevance rules, and it's overseen by the judge, who can limit abusive requests. So even leverage is bounded. Parties can push, but courts can rein it in. The record is another hidden power center. If you want the system to correct an error, you usually need to show it in the record. That means transcripts, exhibits, written rulings, and timely objections. It also means avoiding the common mistake of relying on conversations, side events, or everyone knows narratives that never make it into admissible proof. Appellate courts do not fix what they cannot see. So power often belongs to the party that builds a clean record, not the party that tells the most passionate story. And this is why standards of review matter so much. If you lose on a factual dispute, you're often fighting uphill on appeal because the system respects the trial fact finder. If you lose on a discretionary call, you're often fighting uphill because the system respects trial management. If you lose on a legal interpretation, you may have more room because legal questions are more readily reviewed. Those are not moral judgments. They are structural choices about which institutions are best positioned to decide which issues. Finally, understand that the system is not a single mind. It's a chain. Trial courts manage proceedings and build records. Juries decide facts where juries exist. Appellate courts correct certain errors within standards. Legislatures adjust statutes. And parties drive most of the inputs by choosing claims, defenses, evidence, and tactics. So if you want to understand power in court, don't ask only, who is the judge? Ask, what kind of decision is this, legal, factual, or discretionary? Then ask, what rules govern it? Then ask, what standard of review applies? Those three questions explain far more than guessing motives ever will. Now let's address the emotional part. Why outcomes can feel unfair. A ruling can feel harsh and still be legally correct. Unfairness and legal error are not the same category. If a deadline is missed, the court may have limited authority to forgive it. If a claim lacks an element, it may fail even if the story feels morally compelling. If evidence is excluded, it may be excluded because the rules do not allow it in the form offered. If a party fails to preserve an issue, an appellate court may refuse to consider it even if the issue seems important. To someone living the dispute, these can feel like technicalities. But technical rules are the rails that keep the system from becoming personal and unpredictable. Consistency protects everyone, including people who will be in court tomorrow who have no idea your case existed. This does not mean courts are perfect. Judges make mistakes. Lawyers make mistakes. Juries can get things wrong. Appellate courts reverse decisions. Misconduct exists in every human institution. But many outcomes that look like a judge choosing injustice are actually a system applying boundaries. So who has power in court? Trial judges have power over the process and legal rulings bounded by law. Juries have power over factual determinations bounded by instructions and evidence limits. Appellate courts have power to correct significant legal error bounded by the record and standards of review. Legislatures have power to make law, bounded by constitutional limits. And parties have power more than they realize, because parties control what issues are raised, what evidence is offered, how arguments are framed, and whether errors are preserved for review. Power in court is layered. It is distributed. It is restrained. The distribution is not accidental. It is a safeguard. If judges had unlimited discretion, outcomes would vary unpredictably. If juries had unlimited legal authority, law would lose consistency. If appellate courts were tried every case, nothing would ever end. Instead, the system balances authority and constraint. Each actor operates within defined boundaries. Understanding those boundaries changes the way you interpret what you see. Instead of, why didn't the judge just fix it? You start asking, what authority existed at this stage? Instead of diagnosing motive, you examine mechanism. Courts are not arenas of unlimited will. They are structured environments where power is layered, reviewed, and constrained. Power in court is real, but it is never absolute.
If you like this content, then kindly hit like, subscribe, and share. Caesar commands it.